Hey everyone, it's Rob Ryder. It's all about elections, part 2. And this is Wednesday, March 12th, 2014. My email address is not changed. It's still the court of record at AOL.com. And I prefer that if you wanted to contact me about something that you do it that way, then leave me something on the video, because I don't hardly read any of that stuff. The court of record at AOL.com is the easiest way to get a hold of me. Or my phone, 616-712-6179. If you can, please do donate. It's middle of the month, and asking again. Well, it seems like I ask all the time. Like I never have any money. I guess that's the way God wants it. Donate. Ashley Rytlewski, gmail.com is the PayPal account name. Snail mail to Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. And just a few points that I pointed out before at the beginning. I'll do it again. This is a Michigan compiled law, 168-845, certifying correctness of statement, certificate of determination, certificate of election, declaration of vacancy, publication of constitutional amendment. So basically it says the members of the Board of State Canvassers shall determine which persons have been duly elected to each office. This is on the state level. Circuit court judges are state level. The board shall certify the determination and deliver the statement and certificate of determination to the Secretary of State. So the first thing that happens is after the election is the Board of State Canvassers gets together and they certify this document called certify the determinations and deliver the statement and certificate of determinations to the Secretary of State. First thing that happened. All right. The Secretary of State shall file and preserve the statement and certificate of determination. So if you want to find out if somebody actually won the election, you could get a hold of the Secretary of State and ask him for the certificate of determination for whatever office it is you're interested in. And then they shall immediately execute and deliver a certificate of election to the person elected. So the certificate gets filed in the office, and then they turn around and they produce a certificate of election, and they send it out the door. If the Secretary of State receives notice before the certificate of determination is issued, so before the certificate of determination from the State Board of Canvassers is issued, that the person to whom the certificate of election is to be issued died, okay, that would be one good reason, withdrew from the district, was declared legally incapacitated by a court having jurisdiction. Legally incapacitated. Like a protected person. That almost sounds like a probate court. Or submitted to the Secretary of State an affidavit declaring that person's intention to refuse the certificate of election. Decided I don't want to be elected. Then the Secretary of State shall not issue a certificate of election, and the office shall be declared vacant as of the commencement of the term of the office which that person would have been elected. Conversely, if the person elected didn't send their affidavit saying they're going to turn down the office before the determination was made, then they would issue the certificate. And so there would be a certificate that showed that somebody had been elected, even though that somebody had sent an affidavit to the Secretary of State saying they were refusing the office. Oh, but I have the certificate. I guess they don't care that I refuse the office. I'll go ahead and claim the office. So, right, now would somebody do that? Would they be that devious? I don't know. But just because they have a certificate of election doesn't necessarily mean that they're elected. What does the Secretary of State have? Does she have anything from them saying that they died, withdrew from the district, declared legally incapacitated by a court having jurisdiction, or an affidavit declaring the person's intention to refuse the office? You have to check both ends. County office vacancy. So if this has happened now and there's a vacancy in an office, if the vacancy is in the office of county clerk or prosecuting attorney, it shall be filled by appointment by the judge or judges of the the judicial circuit. Does that mean they're going to appoint the judge or judges to the office? Or are the judge and judges going to appoint somebody else to fill the office? I don't know. If the vacancy is in any other county office, the presiding or senior judge of probate, the county clerk, and the prosecuting attorney shall appoint a suitable person to fill the vacancy. Well, what if they don't agree on the same person? It doesn't say they're going to vote. It says the presiding or senior judge of probate, the county clerk, and the prosecuting attorney shall appoint a suitable person to fill the vacancy. I wonder if that person has all those hats. He's the presiding judge, he's the county clerk, and he's a prosecuting attorney. I don't know. Funny how they write these things. Okay, and why is all this important? Well, one of the reasons it's important is, I think that realize we're in a bankruptcy, and where did the bankruptcy start? Well, it started at the local government level, and that's your smallest self-governing district. It could be a financial emergency of the local government, and if the local government is a school district, so your local government where you are could be a school district. Now again, a school district could be a single school and the district around it that the kids in that district go to that school. That's a school district. Not necessarily that, conglomeration of that we think of as a school district passing all this crazy ass stuff you don't want your kids part of. Right? It's called a school district, but it doesn't necessarily mean it is the school district. But if they declare a financial emergency, then this section empowers the local government of which an emergency manager has been appointed to become a debtor under Title 11. Going to make the local government a debtor. And the local government of a school district is really the people in the school district, or, in any district. The electors are the government. And so they're going to put all the electors into bankruptcy. Whether they're a registered and qualified elector or just an elector, by the fact that in Michigan to be an elector, you only have to be over the age of 18 and lived in the state a year, I think, or something like that. Yeah, we'll look at that in just a second. Anyways, just some of the things about elections. And so in the last one, we were looking at some oaths, right, to find, because that's one of the things you would look at is somebody's oath to make sure they have an oath. And then I found this crazy thing that Jerry Stanton sent to me. This is, let's make it a little bit smaller. Okay, this is for a probate judge in Branch County, Michigan. Now, one thing to notice, see, they got a signature line and they have name printed or typed. And so that's for the guy taking the oath. Now this is the subscriber, signature, title, name printed or typed. And while you can't see the asterisks, those asterisks go over here. And this first one is, this information is required if oath of office taken before someone other than a notary public. So that goes to where it says circuit court judge. There's an asterisk there that you can't see, but there is. And then when filing with Secretary of State, original signatures are required. And that doubles one went up here to where the signature is. So what this is saying is, if it's not a notary doing this, then you have to put the title. And you have to have the printed name and a signature. And the signature is supposed to be the full name, so P. William O'Grady I don't think makes it, because I don't know anybody has a name of P. Although I did read that a Christian name could be a single letter. It could be that that's okay. Most of these judges, when you look at it, if you start looking at their family histories, judges have been judges for many, many years. You can have family trees of judges that go back a number of generations. Well, if anybody knows what's going on, it'd be the judges. So, right, they give their kids an initial for the first name. And then they start telling the secrets, and they just grow up in the system. Now, this is what, I don't know what to make of this, because when I first looked at this, I said, oh, this is the Great Seal of Michigan. Right? And that would make sense, because this was a circuit court judge. A circuit court judge there is only one circuit court in Michigan. Right? We have one court of justice, consists of a Supreme Court, a Court of Appeals, a circuit court, and a probate court. Circuit court judge, state office, he did it. Well, he's going to use the Great Seal. Okay? And if you know anything about Michigan, it's, this is something of what it looks like, but in reality, this is what it looks like. You got an elk on one side and a moose on the right hand side, eagle in the middle. Great Seal of the state of Michigan. Alright, so just pay attention to the back of this moose. See how it's nice and straight and goes up to his antlers, right? See this moose here? If it's a moose, he's looking back over his back. It's a fictitious seal. Now it does say seal of, and then we lost the rest of it, so I don't really know what it says. But it ain't the Great Seal of the state of Michigan, that's for sure. Now, I don't know if this could be Branch County's seal or not. I mean, that's a possibility. I didn't look at Branch County's seal. But it ain't the Great Seal of the state of Michigan, because that moose is looking over his hindquarters. He's not looking towards the eagle's butt. It's not the Great Seal. There's something wrong with that. There's something wrong with that image. Okay, but enough on that. So we're going to move on now to what can we do with all this? Well, what else is there to look at? All right, because we can look at all this, and obviously, as you've seen, they can have lied, cheat, and stealed even on the oaths. Man, they can put a seal and say it's the Great Seal of the state of Michigan, and have the moose looking over his rear end. Well, there's more that we can look at, and this is the important stuff, as far as I can see. Because, right, as Lord Coke said, point out their error early and see their last. Right? Find the first thing they did wrong, make that the issue, and everything else doesn't matter, right? Because they can't get past the first thing they did wrong. Well, so I did a search in the Michigan compiled laws on the words elector first and then judge, right? Because it's a multiple search. So whatever you can do, if you put elector, judge in parentheses, then it wouldn't work, right? You got to do elector first, get all the electors, and then judge, get all of them to say judge. It was kind of the idea. But I added some to it after I did that. So the first one is qualified elector. What is a qualified elector, first of all? Except as provided in subsection 2, the term qualified elector, as used in this act, means a person who possesses the qualifications of elector as prescribed in section 1 of the Article 2 of the State Constitution 1963, who has resided in the city or township for 30 days. Right? So you're an elector if you're over 18 and been in the state for a year. You're a qualified elector if you've met that requirement and been in a particular city or township for at least 30 days. You're a qualified elector. But you're not a registered qualified elector, you're just qualified elector. Now let's look at some of these offices, right? Office of Judge of Court of Appeals. A person is a registered and qualified elector of an appellate court district and files an affidavit of candidacy. Right? That's two things a judge has to do to be a judge. He has to file an affidavit of candidacy, and he's got to be a registered, qualified elector of the appellate court district. Now, what we're going to see is where you register as an elector is in an election precinct. An election precinct is smaller than a township. In Michigan, we have townships about 6 mile by 6 mile. There's 3 in every township, or so it appears. I think Bobby in Arizona said that in Maricopa County there's 740 election precincts. I don't know how big Maricopa County is, but that's a lot of election precincts. So if the judge hasn't registered and qualified elector, if he hasn't registered in an election precinct, and when you do this, there's a form you're supposed to fill out, and there's a book it's supposed to go into, and there's evidence that you've done this. It's, there's evidence. Oh, if he hasn't done that, it doesn't matter what else he's done or not done. He's not a frickin' judge. You can't be a judge unless you're a registered and qualified elector. Period. After that, well, you have to have filed an affidavit of candidacy. It's the same for a judge of the circuit court. Now here it says registered and qualified elector of a judicial circuit, right? And this one said registered and qualified elector of an appellate court district, but that isn't where you register. Sure, if I register in my election precinct, I'm still registered within the county because my election precinct is within this county. I'm registered within the state because my election precinct is within the state. I'm registered within a certain congressional district because my precinct is within that district. But you register in the district, some little small area. And they're going to have a book. Now, they don't want to give this information up. Found this out over the last couple of years, but it doesn't change the fact of what it says. So forget the fact they have an oath, because the oath could be a lie, right? Are they a registered and qualified elector? If they're not, they can't hold the office. Municipal judge, registered and qualified elector of the municipality, and files an affidavit of candidacy. As you can see, judge of probate, registered qualified elector of a county, and affidavit of candidacy. Can't get past it. Judge of the district court, registered qualified elector of the judicial district and election division. I'm not sure what an election division is. That was one that kind of sits there by itself. And an affidavit of candidacy. Can't get around it. We already talked about this. This is, entitled to register as an elector in the township, city, village in which he or she resides. So to start out with, right, it's at least no bigger than your township, city, or village, but it's actually smaller than that. What do we got here? County Road Commissioner. Well, I think it said the same thing for him, but I wasn't so much interested in the commissioner. Because it was talking about the judge of probate. Judge of probate. He's one of the top dogs. School district. Registered resident elector. They have to be residing within their school district. District judges, registered elector of the district and election division, registered elector qualified to practice law, registered elector, registered elector, registered elector. You got to be a registered elector. I already did that one. Now search on elector and then register. Okay, a county executive who is a qualified elector in the county shall be elected on a partisan basis, right? County executive has to be a qualified elector. County officers. Office person shall not be eligible for the office of county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, or coroner if the person is not a, you guessed it, registered qualified elector of the county, which means within a precinct within their county. They can't hold the office. Residence defined. That's a good one. Residence. Using this act for registration and voting purposes means the place at which the person habitually sleeps, keeps her personal effects, and has regular place of lodging. If a person has more than one residence, or a person has a residence separate from his or her spouse, the place in which the person resides the greater part of the time shall be his or her official residence for the purpose of this act. Long way of saying, well, what's the place? The place isn't your house. In local actions, the plaintiff must lay his venue in the county in which the action arose. It is a general rule that the place of every transferable act stated in a pleading must be distinctly alleged. And some place must be alleged for every fact. This is done by designating the city, town, village, parish, district together with the county in which the fact is alleged to have occurred. Right? So the place is the city, town, village, parish, district, blah, blah, blah. So when they talk residents, they're not talking anything other than city, town, village, district that you're in. And that could be important when you fill out paperwork, when they want to know where your place is. We know they like to try to trick us with the paperwork. Where are we at here? Okay, search on judge of probate. Unless the person is registered for a qualified elector, we know that. In a general nonpartisan primary election, the Tuesday succeeding the first Monday of August preceding the general November election, okay, at which time the qualified and registered elector may vote for nonpartisan. So here's the other thing. The only people that can vote for the judge of probate are other qualified registered electors to vote. Okay? Well, if you're not qualified and registered within your election precinct, you don't get to vote for what matters. You want to be registered as an elector. If upon the expiration of the time for filing petitions or incumbency affidavits of candidacy for the primary election, here's another thing. They have this thing called an incumbency affidavit. Right? Here's another thing, that if it's an election and somebody is the incumbent and they are going to run again, they have to file an incumbency affidavit. Filing petitions or incumbency affidavits of candidacy for primary elections. Filing petitions so it can be a petition of candidacy or incumbency affidavit of candidacy, I guess it is. There's two different things there. Judge of probate. Except as otherwise provided in this section, to obtain the printing of the name of the person, the candidate for nomination of an office of probate or judge of probate, upon the official nonpartisan primary ballots. And this is interesting because they have these other ones that are, they have these ones that are official primary ballots, and they have these ones that are primary election ballots. There has to be a difference. We have these things called official nonpartisan primary ballots. There shall be filed with the county clerk of each county nominating petitions containing the signatures, addresses, dates, signing of the qualified and registered electors residing in the county as determined by whom. So for a judge to be nominated on a nominating petition, it takes qualified and registered electors to do it. To obtain the printing name of the blah blah blah. Okay, and this is if it's in a district. There shall be filed with the Secretary of State nominating petitions. Nominating petitions filed in this section are valid only if they clearly indicate which of the following offices the candidate is filling, consistent with something: an unspecified existing judgeship for which the incumbent judge is seeking election, an unspecified existing judgeship for which the incumbent job is not seeking election. Well, how can there be an unspecified existing judgeship, right? This is for a probate judge, but it's not specified. And this is because I think that there's a group of people that make up a jury of proof that have put us into the system we're in now, and there's a jury involved, and that jury makes up the court of probate. And so there's numerous judges of probate within the county. I'm thinking. I have no evidence to substantiate that. Just from what I've read, it kind of seems like that's a possibility. It's not necessarily the guy that you see when you walk into there's a judge of probate. Yeah, is he? I don't know. How do we find out? Well, you go and find the nominating petitions. You go to the county clerk and say, I'd like to see the nominating petitions for judges of probate from last election. Right? Because they're either filed with the Secretary of State or they're filed with the clerk. These are public records. These may be good records to go look for. The nominating petitions. Incumbent probate judge filed with the county clerk, or in case of a probate district, with the Secretary of State, an affidavit of candidacy. All right, so if they're the incumbent, they do an affidavit of candidacy. If they want to be nominated, they do a nominating petition, apparently. Okay, easy enough. So the other thing you would ask for is affidavits of candidacy for, well, let's get all the judges. The affidavit of candidacy shall contain statements that the affiant is an incumbent probate judge of the county or district in which the election is sought, and he or she is domiciled. We like to be domiciled. That's the whole point. Domiciled within the county or district. And how do you become domiciled? When you register as an elector within your election precinct. You will have appeared before the proper magistrate. Certificate of nominations, death or disqualification of candidate. If after the deadline for filing nominating petitions under 433 there are fewer candidates for nominations or nominees for office of judge of probate than there are persons to be elected, right? They're talking about multiple persons being elected for the office of judge of probate. Well, I don't know. I live in a pretty big county. I think there's only 2 guys that are judges of probate. Hell, there may only be 1 that you can see when you look at the website. And this is talking about there being fewer candidates than positions. You're going to tell me somebody doesn't want to run for judge? That's crazy, man. I can't see where they'd be not enough. All right, so that's why I think it's, we're talking about a grand jury or petite jury. A number of people sitting together as a jury, because when there's a jury invoked, it's the judge. And the judge is the administrator of their orders. But they'll be filing a nominating petition with the county clerk. Again, go to the county clerk, say you want to see the nominating petitions for the judges of probate. Far back as you can go. Say, just bring me the book. I want to look at the book. It's a public record, isn't it? I want to check the book out. Judge or judges of probate, election in probate court, district. Except as otherwise provided in a section, a judge or judge of probate shall be elected each probate court district created pursuant to law and each county at the general November election in which judges of probate are to be elected as provided by law. Each probate court district created pursuant to law and each county shall have that number of judges of probate as provided by law. These are for people in Michigan, when you read the compiled laws and you see the lowercase word district court, I think they're talking about district probate courts. Not only counties, because a county, when you read in the Constitution when they did this, right, each county would have a probate court. And it could be called a district. They're not talking about the district courts we have, capital D district. This is a different one. Right? It's the court of proof. And so, in whatever these districts are, now these districts could be smaller, and I think they are. It probably is the district size that we see now. It just isn't the district court that we think it is. That's the fictional court. These are hiding in the background. Probate judge certificate election by Board of County Canvassers. The Board of County Canvassers, now this is the county instead of the state, shall determine which candidate or candidates of the office of judge of probate receive the greatest number of votes and shall declare such candidate or candidates duly elected. The said board shall forthwith make and subscribe on its statement of returns a certificate of such determination and deliver to the clerk. I would like to see the statement of returns subscribed by the Board of County Canvassers for the probate judges in the last election, please. Thank you very much. Just bring me the book. Right? Because if you don't bring you the book and you make a copy, you may find what we found in some of these oaths. They cover up the bottom of the oath and make a picture of it, right? They conceal the evidence. Right? You want to see it in the book. You want to hold it in your hand. You tell them, no, I want to hold it. Bring it here so I can look at it, and then I'll tell you if I want a copy or not. And say, can you take it out so I can see the back? And make sure there's nothing on the back. Right? Because we're only ever seeing the front of the paper, and paper's got two sides. The county clerk shall file in his office and preserve the original statement of determination. Can't say they don't have it, just said they do. And cause to be delivered to the person, the probate judge, a certificate of election. I'd like to see the certificates of election for the judges of probate, please. Probate judge, term of office. Okay, well, basically, this had to do with 1964. After that, I think there's 6 years or something like that. Probate judge, oath of office. You're going to take the oath of office. File the same with the county clerk. Okay, so now we're getting to the oath. He had to do all these other things to get to the part of doing the oath. Right? So this isn't the first thing. We need to go to the first. And the first is he needed to be a qualified registered elector within his precinct. Any person duly elected to the office of judge of probate who desires to resign shall file a written notice containing the effective date of such resignation with the court administrator and a copy with the governor and secretary of state. Now, who is the court administrator? Well, I believe the court administrator to be the chief judge appointed by the Supreme Court over the circuit court. Because it says he's the court administrator. I'm not going to argue with it. His job is to administrate the court. So the chief judge who was appointed by the Supreme Court into his office is there for one reason. He is the court administrator. He's administering the business of the court. He may have a court administrator. He may have a clerk. He may have all these, but he is the administrator, the chief executive of the court. The office of probate judge shall become vacant upon the happening of any of the following: death of the incumbent, he resigns, his removal from office, ceasing to be an inhabitant of the county, his conviction of an infamous crime, or any offense involving a violation of his oath of office, the decision of a competent tribunal declaring his election or appointment void. And we need to find out who is the competent tribunal they keep talking about when they're talking about frickin' competent tribunal. I need to go check that closer and see if, do a search on competent tribunal within your state statutes, laws, whatever, and see if it tells you who it is. Or let's go ask them. Or his neglect or refusal to take and subscribe the constitutional oath of office and deposit the same in a manner and within the time prescribed by law, such as filling the damn thing out correctly. Any person holding the office of probate may remove from office upon conviction or impeachment, conviction in impeachment proceedings. Well, that's one way to do it, impeachment proceedings. Another way to do it is this way. This is the office of probate judge. The office of probate judge compared to office of judge of probate. I think they're two different offices. This office you need to be impeached. This one ain't quite so hard. I got all sorts of ways you can be removed from office. So is there a difference between the office of probate judge, which shall become vacant upon the happening of any of these numerous things, MCL 168.442 if you want to pull it up online and read it closer, compared to 168.443, which is the next one, a person holding the office of judge of probate may be removed from office upon conviction and impeachment proceedings for the reasons and manner set forth in Section 7, Article 11 of the State Constitution, or the governor shall remove any judge of probate upon concurrent resolution of 2/3 members elected. A little bit harder to get this dude out of office. Yeah. Interesting. Probate judges, primary election recount. I don't think any of this other stuff was really that important. No. This had to do with schools. Okay. I don't want to make this video too long. You're getting the point of what I'm talking about. There's other things we could be looking at other than what we are looking at. Okay, search on registered elector. Let's see what we can find. Just registered elector. A registered elector of a municipality means a registered elector residing in a municipality, or if the municipality is a township, a registered elector residing in a portion of the township outside the limits of any village, like a election precinct, which is a portion of a village or a portion of the township. Okay, the governor or lieutenant, they have been a registered elector. School board member, qualified registered elector. Every registered elector may vote on the adoption of the Constitution, right? So if you want to vote on any changes, you need to be a registered elector. Tax election. An election for a tax shall be conducted by city and township clerks and election officials in municipalities located in the territorial authority. The village clerk shall provide to the township clerk a list containing the name, addresses, birth date of each qualified registered elector of the village residing in the territory of the authority. So the village clerk is supposed to have a list of who these people are. Board of State Canvassers. Guess what? They need to be qualified and registered electors of the state. So if these people are holding these positions, they can't hold the office. Right? Don't let them buffalo you. It's just some dude wearing a skirt. Board of City Election Commissioners. Should only one of said officers be in attendance on the day appointed for the meeting of the board, the officers in attendance shall appoint a qualified registered elector of the said city to act in the absentee's stead. They just pick somebody off the street, if they had one. Board of Township Election Commission members, blah blah blah. Guess what? They need to be qualified registered elector of the township. Presidential electors, right? Not voters. Presidential electors. No person shall be eligible to be an elector of president and vice president who shall not have been a citizen of the United States for at least 10 years and a resident and registered elector of a congressional district for an elector representing a congressional district or of the state. Right? Registered elector, you get to vote for the president. Or you get to elect the president. Not vote, you get to be an elector. County Road Commissioner, qualified registered elector. School board, yeah, same thing. Township clerk. If neither the township clerk nor deputy township clerk shall be available to perform any necessary functions in connection with registrations, and they don't seem to know what they are, nominations or elections during the usual or required times for performing such functions, the township board shall appoint some qualified person who is a registered elector of the township to perform such functions until such time as the clerk or deputy resume their duties. Because the deputy and the clerk may not be registered electors, they couldn't do this. Any such person so appointed shall have all the powers and authority of the deputy appointed by the clerk pertaining to registration, nomination, elections. So instead of going down there and asking them again about becoming a registered elector, I think I'll go down there and ask about nominations. Who's in charge of nominations? That's pretty benign. Right? They give you that name, well, that person's in charge of registration also. Voting and canvassing. Determination if candidate is a registered elector. Certification. A delegate ballot shall be voted and canvassed by the precinct inspectors. We have precinct inspectors. The chairperson of the board of a precinct election inspector shall determine if a candidate is a registered elector in that precinct. If the candidate is a registered elector in that precinct, the candidate's name and address shall be certified to the county clerk. Excellent. I got to find the chairman of the board of precinct election inspectors and ask him, hey, how do I become a registered elector in my precinct? So that you can tell the county clerk that I am. Outstanding. Registration or change of registration of a person. Secretary of State or the Secretary of State's agent shall afford a person who appears in the Department of State branch office, blah, 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 to be a registered elector. And then they're going to have you fill this thing out, this application. Application for registration made under the section shall contain the following information. And you read through it and it's like, yeah, things you would think. But then down here it says, a place for the applicant to sign and certify to the truth of his statements on the application. Well, that makes it an affidavit. Right? This is a registration affidavit they're talking about. They call it an application, but it's an affidavit. This is 168.500A. Registration cards, master file. The original registration card shall be filed alphabetically hereinafter and shall be termed the master file. The master file shall contain the signature of each elector registered in the city, township, village, unless the clerk or the jurisdiction has access to the qualified voter file and the elector has digitized signature in the qualified voter file. The master file and precincts file shall at all times remain in the custody of the township, city, village clerk, as the case may be, except that precinct files shall be delivered on election day to the inspectors of the elections in the several precincts, blah, 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 blah. Now, looking at some law in Illinois, it said that under township, organized townships, that the township was an election precinct. Well, then that means the election precinct is the township, right? So whatever size the election precinct is, it's the township. So these files aren't necessarily in the township hall that we see when we drive around. We got them all over the place, right? Every township got a township hall. It's not what they're talking about. It's wherever the precinct is, because it's possibly the township. Could be a church. Probably is a church. Some protester church. Church of the Protestant. Because this whole system was set up by Protestants. Execution of the new registration affidavit. If either original or duplicate registration card gets destroyed or mutilated, it shall require the execution of a new registration affidavit by the elector. So this is how they clean up their mess, right? They burn everything and then they say, hey, you need to come down and fill a new card. Oh, you didn't know that? Well, you're no longer a registered elector. 20 years from now, your kids won't know they were supposed to have done it, and we'll be back to where we were before. Alright, that's what all these fires are for. Get rid of the records, scatter the sheep, they'll forget what was going on. When they get back, give them some sugar, give them an iPod, iPad, whatever. Alright, and let the games begin. If any such elector shall refuse or neglect to execute such affidavit within 60 days after the mailing of a letter to the such elector at the last address, well, that's the question. What is the last address of the registered elector? Right, boom. You'll no longer be registered as an elector. At the time an elector is applying for registration, the registration officer shall ascertain if the elector is already registered as a voter. Right? You're coming to register as an elector. They're going to find out if you're registered as a voter. If an elector is previously registered as a voter, the elector shall, at the time of applying for registration, sign an authorization to cancel a previous registration as a voter. The Secretary of State shall prescribe forms for this purpose. The form may be part of an application or a separate form. Change of address. A registered elector may, upon change of residence within the township, city, or village, cause his registration to be transferred to his new address by sending to the clerk a signed request. The clerk shall strike through the last address, ward, precinct number, so the precincts have numbers, and shall record the new address, ward, and precinct number on the original and duplicate registration cards, and shall place the original registration card in the proper precinct file. So in the city they're called wards. Out here in the country they'd be called precincts, apparently. A statewide street address index in electronic medium will be accurately identify the city township of each record, and by January 1st, 1998, accurately identify the precinct of each record in the qualified voter file. Qualified voter file shall contain all the following information for each qualified voter: precinct number and ward numbers, if any. If you don't have those in there, then you're not qualified as an elector, you're just qualified as a voter. Right? Because even as a qualified elector, you're still going to vote. It's just you get to vote for the things that count. Oh, division of wards or precincts. Okay, they can split them up, and then they got to transfer the precinct cards, shuffle the deck, hope you don't pay attention. Right? So my thought is, when I get this figured out on my birthday, every year that'll be my birthday present to myself, to go down there and make sure my stuff is still where it should be. They haven't done something that I don't know about. If the registration of elector is canceled, right, how could that happen? The clerk shall make a proper entry of the original duplicate, blah, blah, blah. The clerk may also destroy the original registration cards of electors 5 years after date of cancellation of the elector's registration. Registration affidavit, contents, right? This really has all the same things on it we saw earlier. They said you could do it at the Secretary of State's office. 168,495. Right? It's a registration affidavit. If you want to be a registered elector, you got to do an affidavit. You want to be a registered voter, you just fill out a piece of paper and give it to them. Registration of elector. If an applicant for registration is unable to write, then he shall execute the registration affidavit by making his mark, and there shall be noted upon the registration cards the month, day, year of his birth. Right? Apparently you have to do a thing called a registration affidavit. So where is the judge's registration affidavit? I'd like to see it, please. If there's no registration affidavit in the precinct for these yahoos, they can't hold the office. The law says so. Yeah, this is back to that require execution of the new registration affidavit by such elector, blah, 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 blah. If upon the examination of registration records of any city, township, or village, the Secretary of State determines that the registration records fail to comply with requirements of this Act, the Secretary of State may order the clerk, secretary, so forth to, redo. He may apply to the circuit court of the circuit in which the city, township, village is located, order re-registration of qualified electors in the city, township, village. So if they come and say, hey, we got too many registered electors, we can't pull off our scam, we're going to have them re-register. We'll see if they're paying attention. Now, we can change these laws once we become registered electors. Until then, we got to deal with what's on the table. So make sure you get registered, you stay registered. Upon a proper showing of need, the court shall issue an order. Well, what's the need? Well, the Secretary of State says so. Okay, that's good enough for me. And registration of electors. They talk like this doesn't exist. Well, you can be a voter. Well, no, I want to be a registered elector. Well, all we have is voters. Well, registration of electors has got, 1 page, 2 pages, 3 pages, 4 pages, 5 pages, 5 pages and a couple of sections of law having to do with registered electors. So, apparently, they exist. Okay, certificate of election. The Secretary of State shall file in his office, preserve original statement of determination. That's the first thing to do. The Secretary of State shall file in his office, preserve original statements of determination, cause to be delivered, certificates of election. So, again, Let's say they are a registered elector. Okay, then where's the original statement and determination from the canvassing board that needed to be certified prior to the certificate of election being created? And by the way, do you have any notices where this person may have been found to be have a legal disability and can't hold the office? Representative in Congress, they would have a certificate of election. State senators, they would have a certificate of election. County officers, the county clerk shall file in his office and preserve original statements of determination of the Board of County Canvassers of the results of the elections, shall immediately execute and cause to be delivered to the persons elected offices named in section 200, properly certified certificates of election, certified by him under the hand and seal of the county. The county clerk shall cause a copy of the certificate of determination together with statements, blah, 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 blah. Right? So, certificate of determination and then certificates of election. The county clerk, and this is the people that have to have section 200, a county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, and surveyor, all have to be on the original statement and determination for their election and have been given a certificate of election properly certified, and file an oath and file a bond before they can hold the office. 6th Tuesday of the deadline to file a nominating petition, office clerk, register of deeds. I don't know what that was about. That was more on this. The county clerk shall file in his office preserve the original statement of determination of the Board of County Canvassers. Results of election shall immediately execute, cause to be, this for the county auditor, right? So the county auditor, certified by him under his hand and seal of the county. So I don't know why they put the county auditor in a different group than all the other county yahoos. These guys here, here's section 200. Why is the county auditor separate? That's interesting. Auditor is a ecclesiastic term. Auditors are who talk to the Pope. He has his group of auditors. County Road Commissioner, certificate of election. State Board of Education, certificates of election. Supreme Court, certificate of election. You know, we should go check to see if all these people have certificate of elections. Are they registered electors or not? And point them out and say, hey, either step down or there's an insurrection and we're going to have to call in the military. Certificate of election under the Great Seal of the state. Just make sure the moose is facing the right direction. See, Circuit Court under the Great Seal of the state. Probate judge. The Board of County Canvassers shall declare such candidate duly elected, subscribed on a statement, return, certificate of determination. There you go. Now it says probate judge. It does say seal of the county. The county clerk shall file in his office preserve the original statement of determination. Oh, this is for the certificate of election under the seal of the county. Does the probate judge have a certificate of election under the seal of the county? Do these other judges have under the seal of the state? Well, if it's under the seal of the state, you would check with the Secretary of State. Seal of the county, county clerk. District Court judges, the Secretary of State shall file and give certificate of election. You want to know who the District Court judges are? Get a hold of the Secretary of State. Filing a certificate of determination, certified certificate of election. The Board of County Canvassers shall determine and declare the results of elections for county and local officers. Not just the county, but also local. Upon making the determination under the subject, under the subsection, the Board of County Canvassers shall prepare a certificate of determination and deliver the properly certified certificate of determination to the county clerk. Upon receipt of the properly certified certificate of determination of the Board of County Canvassers under the section, the county clerk shall file the certificate in his or her office. The clerk may have a statement of the total county or district votes cast for various candidates, and the total vote cast for or against various ballots, questions at the election, to be published in at least one newspaper printed or circulated in the county. May have. The county clerk shall immediately execute and deliver to persons declared elected a properly certified certificate of election. And this is for county and local officers, township officers, city officers, village officers. Certifying correctness of statement, certificate of determination, certificate of election, declaration of vacancy, publication of constitutional amendment. And this is the one where the members of the state board shall certify the correctness of their statements, determine which persons have been elected, each office, and which constitutional amendments have been propositioned, if any have been approved. And if the Secretary of State receives notice before the certificate of determination is issued that the person, for whatever reason, isn't taking the office, then he won't issue the certificate of election. But if he doesn't get that prior to the certificate of determination being completed, then he's going to go ahead and send the certificate of election to somebody who may have sent, although a little bit too late because you know how the mail is, may have the wrong address, and sent to the Secretary of State saying he's not taking the office, but now, hey, well, I guess they want me to really take the office after all because I have the certificate of election. And they haven't called me yet, so I guess I'll go ahead and take the office after all. Even though I'm not in the office because I have filed my certificate or affidavit saying I'm not taking the office. Board of Trustee. Trustees, I think this is for, I want to say that this is for the township. Official canvass, the secretary of the final board of canvassers, the election members, the board of trustees shall deliver, unless it's for a school board. Oh, well, it's church trustees, that's who it is. Even the church, so much for separation of church and state, even the church has got a frickin' state law on doing their elections, and my gosh, if they don't get certificates of election also. Are you really the bishop? Come on, show me your frickin' your certificate. Yeah, certificate of elections, blah, blah, blah. Okay, we're about done. Some of these, I don't think the rest of these are quite that long. But they all have interesting things on them, so it's hard not to show them to you. This is for Illinois. The canvassing boards are abolished. Notwithstanding any other provision of this code, local canvassing boards, now we were talking about the county canvassing boards in Michigan and how they would give these determinations and end up with a certificate of election. Well, they don't have those in Illinois. They've been abolished. In this code or any other law referencing local or county canvassing boards means, 1, for elections in which political subdivision, that is choosing candidates or submitting a public question, is located entirely within the jurisdiction of a single election authority, that election authority, and for elections of office of public questions not listed in something, political subdivision, that is choosing, well, what is all that saying? Is saying that the canvassing or that the law references, where it talked about it before, now they mean within the political subdivision. So I think it gets a little more clear down here. The returns of judges of elections of such village or incorporated town mentioned in the last section in case of village town election or any officer of such village or town shall be made to the same officer as otherwise required by law, who shall receipt thereof returns shall be canvassed by the election authority of such village or incorporated town as established by law, with the same powers of investigation and examination by election authority. That ain't telling me anything. The word township and the word town shall apply interchangeably to the type of government organization established in accordance with provisions of the Township Code. Now, in Illinois, they have these buildings called Town Hall. Rose said there's one right down from the Township building. Town Hall. It's where the road district is. It's the Town Hall. That could be the, what the election district is, or the election precinct is the Town Hall. The word township and word town shall apply interchangeably. The term incorporated town shall mean a municipality referred to as an incorporated town in the Illinois Municipal Code, as now and hereafter amended. So I guess you look in the Illinois Municipal Code for an incorporated town, or you go down to the building that says Town Hall, because there's people in there working, and say, hey, is this the incorporated town for the Illinois Municipal Code? Election authority means county clerk or a board of election commissioners. Election jurisdiction means an entire county, in the case of a county in which no city board of election commissioners is located, or which is under the jurisdiction of a county board of election commissioners, the territorial jurisdiction of a city board of election commissioners, and the territory of a county outside the jurisdiction of a city board of election commissioners. In each instance, election jurisdiction shall be determined according to the election authority maintains the permanent registration records of qualified electors. They have it in Illinois also. Whoever has the permanent registration records of qualified electors is the election jurisdiction. Local election official means clerk or secretary of a unit of local government or school district. Right? School district. A local election official means the clerk or secretary of a unit of local government or school district. That's because school districts can be local government. As the case may be, the treasurer of a township board of school trustees. Because the original survey townships were set up for school purposes, they were never meant to be municipalities. Judges of elections, primary judges, in similar terms apply to cases of two sets of judges when used in connection with duties at an election during the hours of polls open. Refer to the team of judges, election and duty, such hours, blah, 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 blah. Okay, that don't mean much to me. The main thing I wanted to point out, Illinois got the same thing. Permanent registration records of qualified electors. Walk in with Section 9 of this law and say, where is my election jurisdiction? I live here. To the people in charge of elections and have them tell you. Yeah, Board of State Canvassers determine results. The Board of State Canvassers shall canvass and return and determine the results of all elections for electors, not voters, all elections for electors of President, Vice President of the United States, state officers, United States senators, representatives in Congress, circuit judges, state senators, and representatives elected by district, that is located in more than one county, and other officers as required by law. The Board of State Canvassers shall also determine the result of an election on proposed amendment that has been submitted pursuant to law to qualified and registered electors. They're the only ones who get to vote on shit. And why is this stuff important? Well, because I won't get to it in this video, but I want to point it out again. If you look at a CAFR account for one of these organizations, one of these municipalities, like Rose School District, has $80 million sitting in the bank, cash, or certificates of deposit. $80 million. That's not including what they have invested. $80 million. I don't think they need any more money. Well, somebody needs to go there as a registered elector and say, I vote that we pay the bills and give the money back to the people. All in favor? Yeah, get enough people to vote and you're in. That's why when you go to these frickin' local yokel committee meetings or whatever, and they have public hearing time, well, they're not listening to a word you're saying. You're not a registered elector. You have nothing to say about what's going on. Yeah, they're going to let you have your 3 minutes to talk, but they're not going to pay any attention to you. They may even act like you're not even there. Stare at the wall, stare at the ceiling, look at their watch, sit there like plastic, wait till you're done, next, right? That's part of the show. Got to put up for this right? If you want to be on the inside, you have to play your part in the act, and this is your act for this particular period of time. When somebody comes to that podium, they get 3 minutes to talk, and you sit here and look like a rock. That's all you do. Can you do it? Let's see you do it. Yeah, you're going to do just fine. We're going to make you a township supervisor, county commissioner, whatever it is, right? You have the mentality and the personality of a rock. Perfect job for you. And that's the people you're going up there and talking to. Well, what we need to do is say, well, are these guys, are they qualified to hold the office? Are they registered and qualified electors? Did they put in a nominating petition? Did the Board of Canvassers send a statement back certified that they won? Was there an election certificate of election issued to them? Did they file an oath? Did they file the oath in the proper time frame? Like, you've got to wait until, if you're elected for 2013, you can't go in December 2012 and take the oath. You got to wait till January 2013 and take the oath. Did they file a bond? Right? Lots of things they have to have done. The oath is just one little piece of paper, and it's way towards the end. They get all sorts of shit they had to do ahead of time. And the very first one is be registered qualified elector within a precinct. And so if you were going to court, I'd be demanding, I'd be out looking for that piece of paper. And if they won't give it to you, say you guys are obstructing justice. Right? And we're going to, and you take these complaints then, and I pointed this out in the last one, I don't have the thing ready for this. In Michigan, it looks like you take it to your complaint to the Register of Probate, because they have the power to remove a fiduciary. And that's what a county officer is. An elected officer is a fiduciary. And you point out why they need to be removed from their office. Because they're not a registered elector. Whew. Okay, I'm about done. Anyways. Certify. Prepare a certificate of determination. Certify certificate of determination. That ain't good enough just to have a certificate of determination. We're going to certify the certificate of determination. Shall meet at the office of Secretary of State on or before the 20th day after the election, and no later than the 40th day they'll have produced this paperwork. Expedited canvass of returns for electors, president, and vice president. Certified copies of statements of votes. Yeah, you got to do that too. Certified copies of statements of votes. The Board of State Canvassers shall examine the statements received by Secretary of State of votes cast in several counties and prepare statements showing total number, blah, 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 blah. Okay, declaration of vacancy, I think we've talked about before. Yeah. I just like to have it all over the place, because guy may have put in his paperwork saying that he's not taking the office, and they've already sent him the certificate of election, and I got it, I might as well go ahead and take the office. If the vacancy is in the office of county clerk or prosecuting attorney, it shall be filled by appointment by the judge or judges of the judicial circuit. Does that mean the judge or judges of the judicial circuit are going to take the office of county clerk and prosecuting attorney, or does it mean they're going to appoint somebody? It isn't that clear. Need some annotated versions. What do we got here? County offices. The office of county clerk treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, coroner, in any county, in any state, in this state, shall become vacant upon the happening of any of the following events. These are really the same for all of them. Death of the incumbent, resignation, removal from office for cause, ceasing to be a resident in the county, conviction for an infamous crime, or an offense involving violation of his oath of office, the decision of a competent tribunal declaring his election or appointment void. Why? Because he wasn't a registered elector. His refusal or neglect to take and subscribe the constitutional oath of office as deposit the same in a manner within the time prescribed, or his refusal or neglect to give a bond in the amount and manner within the time prescribed by law. They don't do those things, they vacated the office. You take your complaint to the person who can remove a fiduciary. And in Michigan, it's the probate register. And just real quick, just to look at some of these affidavits that they talked about, right? This is here in a minute. Well, it takes a long time to open these up. All right, this is an affidavit of candidacy. I, somebody, declare that I am an incumbent of whatever district, whatever, a candidate for the office of primary election, licensed to practice law. I have been admitted to practice law for 5 years. I have not attained the age of 70. Okay. I am an incumbent judge for the something, and I am domiciled therein. Okay. So that's one of the affidavits they have to have filed. An affidavit of identity. Now this is interesting. See, here it says I, you got your name, and then in parentheses they have last name, first name, middle initial. But is that really your name? Right? I believe the proper thing to do is you would cross it out and say, well, that's not my name. My name is Robert Allen Rytlewski. Right? They really want me to be Rytlewski, Robert Allen. They want me to accept that name, and I don't want to accept it. I'm going to say that's slander of my God-given character. And if you have that on a record someplace, change your damn record. I'm Robert Allen Rytlewski. Period. But, here's another affidavit they have to have done, and I think on here it should say, I like to find something that has their precinct on here, and I haven't looked that close at this. Office sought. I don't see. Oh, here we go. City or township, precinct, or ward. And this is a nominating petition. This is, what they were supposed to fill out to start with. Now, I'm not going to go into it today. I'm going to save it for another video. There's two offices that can't get away from doing this. It's the governor and the supervisor of a township. Have to do a nominating petition. But it looks like for all these other offices, they could either do a nominating petition or they could spend $100 and get their name put on a ballot. But it looks like the ballots are different. They use different names for the ballots. And okay, that's enough on that. Just some more things to look at, because if you're going to court soon, you got something to deal with, make sure the guy that's sitting there as a judge is a judge. Go find the proof. You find that he doesn't have the proof, he's not the judge. That's all I can tell you. Where are you going to take the complaint to? Again, I believe you need to look to see who can remove a fiduciary, and that's going to be somebody what we would think of as the probate court, because they're the ones who assign fiduciaries. Right? If you were like a guardian ad litem, right? He's a fiduciary. So it isn't just anybody in probate that can do that. That's the ecclesiastic part of the office. The court we see, the probate court, when you walk in, that's just the administrative end for shit that's already been administered, right? But As far as determining who's going to be a guardian ad litem, a conservator, so forth, that's the ecclesiastic part of the probate court. That's the side we're going to, the one that can remove a fiduciary. And as it turns out in Michigan, again, we don't have time to go through this, but this guy has power by the Constitution from the governor to do this. It's really the governor's position to remove somebody from office. It's an executive decision. It's really not judicial. But the governor can't be everywhere, so he had to have a representative, basically. And that's what it says. This probate judge represents the governor. Right? So when you see little g governor, that's the guy they're talking about. They're not talking about the governor of the state. They're talking about the governor of this probate judge acting as the governor, I believe. Yeah, that stuff will prove itself out over time, but let's call it good for tonight. See y'all.